Thank you all for being here. I'm Deborah Rohde, Director of the Center on the Legal Profession, the sponsor of today's program. And my role is simply to introduce and thank two individuals who made today's panel possible. One, Lucy Rica, the Executive Director of the Center, is responsible for almost all of the good things that we do, and today's panel is no exception. Robert Gordon, who had the idea for today's panel, is its moderator. And as many of you know, Bob is one of the nation's most distinguished scholars on the American legal profession and legal history. Although he received his BA and JD from Harvard, we forgive him that, just as we forgive him for leaving a faculty position here for a brief stint at Yale as the Chancellor of Kent Professor of Law and Legal History. He's the past president of the American Society for Legal History, and his forthcoming publications include Lawyers of the Republic and Taming the Past, Law and History and Law. So thank you so much, Bob, for doing this, and I'll let you introduce the panelists.
Okay. Thanks, Deborah, and thanks, Lucy, particularly for doing all the actual work in putting this together. We have a very distinguished panel here. I'll start with Doug Melamed. Doug Melamed's name is very well known to legal scholars since he's the co-author of one of the most famous and most cited law review articles ever written called Property Rules, Liability Rules, and Inalienability, One Review of the Cathedral, Harvard Law Review 1972, which he co-authored with Guido Calabresi, the longtime dean of Yale Law School. This is a path-breaking article. And if Doug had done nothing in his life other than co-write this article, he would already be very famous. But in fact, he's done lots of other things, including being general counsel of Intel for a long period. So he's as a scholar and as a practitioner and as an ex-general counsel, he's kind of an ideal member of this panel. Sung-Hui Kim, is also an academic who's had a long stint as a practitioner. She is a professor at the UCLA Law School and the director of the program on in-house counsel there at the Milken Institute for Business Law and Policy. She also is the inside counsel for Red Bull North America, which she was the first general counsel. She has written extensively on the role of lawyers in preventing or failure to prevent the corporate scandals and frauds, and I think is one of the most perceptive writers in that area of law. Our third panelist provides the objectivity required of someone who comes from a world outside law. Benoit Monin is professor of organizational behavior and professor of psychology at Stanford University. He is he's something of a polymath. He seems to, besides being an expert cognitive psychologist, he also knows a great deal about the business world. He is a graduate of the École supérieure des sciences économiques et commerciales, of the London School of Economics, and of Princeton University. He is particularly interested in the ways in which the people may be induced to behave morally or not morally, depending, among other things, on their psychological limitations and their organizational settings. I need to say a little something about, to set up the problem. Probably most people here have a general familiarity with it. Lucy has done us a great favor of preparing a little slideshow, which gives us the essential background to the GM case. So I'm going to race through this as quickly as possible because I'm anxious to get to our panelists. But I think some background is probably necessary for all of us to see what the fuss is all about. Okay, here's the root cause. Here's the defective ignition switch that has caused all of the problems for General Motors. The effect of the defect means that the switch can be knocked into the off position with very low torque, and a lot of drivers' knees simply flipped the switch into off. When the switch goes off, of course the vehicle's reverts to the vehicle's engine is turned off, the automatic steering is turned off, the automatic brakes are turned off. You can still steer the car, you can still brake it, but only on manual systems. And of course, the main effect, it turns out, is, which GM people were very late in discovering, is that the airbags fail to deploy. Understanding this connection, as they say, took GM 10 years. The context here, the GM's losing money, and it's become very, very cost conscious. The GM's internal principles say if a safety issue is involved, cost should be no object. As a practical matter, of course, they always are in an environment where there's a lot of pressure to cut costs. GM launches the Cobalt. The ignition switch was defective at launch. This was generally known. The GM engineers characterized the moving stall as a customer satisfaction issue or customer convenience issue rather than a safety issue. And in fact, they sent some safety bulletins to the regulator, NHTSA, the National Highway Traffic and Safety Administration, which described the defect but did not characterize it as a safety defect. This classification is very important because safety defects move the problem into a whole different threshold of awareness and trigger a whole different set of responses, both regulatory and internal. There was an article in the Cleveland Plain Dealer that said, "Hey, how come this isn't a safety defect? Nobody's even talking about the airbags yet. If a moving car, the stalls in the middle of heavy highway traffic moving at high speed, and you have to maneuver to get the car off the road, and other cars behind you are crashing into you, how is that not related to safety?" This is a very good question. It was not asked, however, either by GM or by the regulator, NHTSA. Litigation related to unexplained airbag non-deployment starts coming into GM legal. People were baffled by what happened here. They couldn't explain it. They kept explaining it as an anomaly in the switch. They didn't connect it up with the ignition switch issues that had been raised either, and they looked at individual cases. They couldn't at least detect a pattern. Some outsiders did detect a pattern. There's the Wisconsin State Police did an investigation after one of these stills, and they actually correctly diagnosed the problem. Turning off the switch meant that the airbag was disabled. There was a report from the Indiana University Traffic Safety Institute, which came to the same conclusion. The reports were publicly available. They found their way into GM's files, and yet no one investigating the problem at GM found these reports. Then we have 2008, 2009 financial meltdown. There's another piece of background which I should mention here. The defective switch was initially approved for production by one of the chief engineers, Ray DiGiorgio, and he approved it because he couldn't figure out a way to fix it that seemed to be cost-effective and practical. So it went into production into a lot of the early cars, especially the Cobalts. Later on, 2006, DiGiorgio, the same engineer, figured out a way to remedy the problem and fix the switch so that it would have more torque. He did fix it, and so in all of the cars, the new switch went into production, and it was not defective. DiGiorgio, however, never told anybody about the change that he had made, and although it was practice to change the part number when you change the part number was never changed. Still a bit of a mystery. Why did Giorgio did this? Was it to cover up his earlier approval of the defective switch, or was there some other reason? We don't know. Anyway, the fact that the part number was never changed is one of the factors that kept the GM inside investigators from figuring out what the problem was. They didn't figure out the. Meanwhile, in the lawsuits, plaintiffs' lawyers and their experts were figuring out what the problem was by the simple expedient of comparing the earlier switches to the later ones. They x-rayed them and found that they were of different design. This was not, however, known within General Motors. Spring 2010, King and Spalding, who's defending these cases in litigation, warns General Motors of potential exposure to punitive damages because of unresolved investigations into airbag non-deployments, which are called the sensing anomaly. Anomaly because they don't know what the reason is. 2011, the GM lawyers are tasked with trying to figure out why the airbags are not deploying them, and the pattern from here afterwards just seems to be that the investigation continues very, very slowly with very long delays between its phases. There doesn't seem to be much of a sense of urgency. By the way, how do we know all this? Our main source of information on this is a report prepared by Anton Volukas of the law firm of Jenner and Block, which, after all of these failures this year, was asked to conduct an internal investigation, which they did. They looked at hundreds of thousands of documents and interviewed hundreds of witnesses, and the result is a 375-page report, which is available online and contains most of the information that I'm now giving you. NHTSA also, by the way, did its investigations, but NHTSA received 260 complaints about the switch turning itself off with slight movements, but was unable to detect any pattern or trend in what was happening, and therefore did not take any action in response to the complaints. This is from Volukas and his report. The lawyers felt they had done their job by emphasizing the importance of the issue to the engineers, but faced with the pattern of crashes, they did not at the same time elevate the issues to the general counsel and do not appear to have insisted on a quick and concrete timetable. There was a rule of operation within GM that if cases in litigation settled for certain figures, they would have to be reported to the general counsel. If they reached as high as $5 million, more than $5 million, they would have to go to the GC. GM at this time did settle one of these cases, that King and Spalding pointed to as perhaps generating serious punitive damages for exactly $5 million, but still didn't tell the general counsel. In fact, the general counsel Michael Millikan was left in the dark. So the Volukas report, at any rate, found. Eventually, it's the plaintiffs and their experts who actually correctly diagnose the source of the problem. But the internal investigation at GM takes many months to come to the same conclusion. There is this interesting moment where one of the new lawyers at a conference asks why there hasn't been a recall, and he's told that the engineering was working on it. That's it. Now we're into 2013. The investigation is still continuing. The guy who's conducting the investigation, Stauffer, is not finding a lot of the relevant information for reasons that I'm a little unclear of still from the report. He is doing a data search into the litigation, but his search doesn't turn up many of the relevant cases. This may be because of the bifurcation at GM of safety issues between a product safety division on the one hand and a products liability division on the other, which handles the which handles the litigation. November 2013 is when it dawns on the investigating team what the Wisconsin State Trooper had found out many, many years before, that the ignition switch is causing non-deployment of the airbag. Formal steps for recall are started, and finally, the general counsel and CEO are notified at the end of 2013. So I'll leave it at the switch here. So there are many, many more things to say about this case. It's a long and detailed case. Let me first start asking the panel, particularly at the beginning, Doug and Sui, as you look over the facts of the GM case, how would you go about diagnosing why the company is so slow to detect and respond to the problem?
I think there are a lot of lessons that you could draw. The fundamental problem from the legal department's point of view is the legal department had information which, if properly assembled and disseminated, could have saved lives and reduced the company's liability by presumably hundreds of millions of dollars. But the information was not properly assembled and disseminated. I think there are a lot of lessons, about information should flow, and you ought to have processes, and you ought to have a tone from the top, and so forth. But I think the big lesson, if I had to distill it to one lesson, it was that there was not an ownership culture in the law department. That it appears, insofar as you can tell from the report, that the lawyers were, the way I put it, practicing law with their heads down, doing the job that they were given to do, defend the case, stop there, respond to an inquiry, stop there. And no one looked up and said, is there a larger problem here? And if so, am I confident that the right people know about it and are going to solve it? I mean, you don't want everybody. You want to have Indians as well as chiefs, but you ought to have the Indians, I think, alerted to taking responsibility for the project and charged with making sure that somebody knows what needs to be known in order to deal with the project. So you look at the general counsel, and he didn't get fired because he didn't know. Fair enough, and I don't know the particulars there, but to me, the harder question, the more really ominous question is, why didn't he know? What was wrong with the culture in that company and in that law department that no one took responsibility enough to say, wait a minute, we ought to escalate this, or we ought to get that division involved because this problem is bigger than the one case I'm handling?
I absolutely agree. Ben Heineman, who's the former general counsel of General Electric, made the point that GM did not have a culture of accountability, nor did it have a culture that emphasized safety. The one thing that the Valukas report omits is assignment of the blame to those who are responsible for the system. There was no system of accountability. So Milliken, is treated very lightly in the report. He didn't know, and I agree. Why didn't he know? There are a couple of situations, a couple of instances in which I believe that he should have known, or he should have inserted himself into the process. So, for example, GM had a system of settlement committees. One of the committees was called the Round Table. And that committee was supposed to review and approve settlements between $100,000 to about $2 million. So these are pretty significant settlements, mostly involving fatalities. The other committee was the Settlement Review Committee. The Settlement Review Committee is called the SRC. And that committee was responsible for settling cases between $2 and $5 million. And these more junior lawyers, they were fairly senior lawyers, but compared to Milliken, they were They were junior lawyers. There was a safety lawyer, a guy named Jim Kemp, and then there was the head of the products liability cases, a lawyer named Larry Bonomo. And those two lawyers sat in those committees, at least one of those committees, definitely the higher one, the SRC committee. And they reported to the General Counsel of GM North America. And the General Counsel of GM North America presumably reported to the General Counsel of GM, Michael Milliken. And yet, even though they settled cases in those ranges, one for $5 million, they never told the General Counsel. But what's striking to me is, why didn't the General Counsel have regular meetings in which they discussed the cases that were settled, especially one as significant as $5 million? The fact that Milliken did not insert himself into the process such that there was a regular information flowing system is quite shocking in my mind. Having been General Counsel, what a General Counsel does normally is they identify, first and foremost, the chief risks of the company. And for every company, depending on the industry, it will be different, right? So for a pharmaceutical company, it would be what? It would be fatalities, it would be bad side effects. All of these have enormous products liability implications, and more importantly, huge public relations problems, right? For GM, clearly, it's, auto crashes, non-deployment of airbags. What could be more high risk than that? So the GC should have, at the outset of his term, realized that he needs to be kept abreast of products liability cases in which there were something such as non-deployment of airbags or fatalities involved. There should have been a policy of a regular flow of information to him. That was not the case at GM. So that clearly is a failure of accountability for the system that the people at the top should be blamed for. The other thing that I'd like to point out, and this is not just the legal department, but GM in general, is sort of a culture where people did not make waves. I was surprised reading the report that there was no discussion of persons having heated exchanges or kind of tough confrontations or tough words being exchanged by people in power. There was one moment, I think the slide showed it, where the legal department expressed some frustration about things not moving fast enough. But then again, it took them 6 months to schedule a meeting of the key people involved. So they clearly didn't see the urgency of the matter. But I do think at GM and at a lot of companies, there is this tendency for people not to make waves, not to ruffle feathers, not to be confrontational. And there's sort of a catch-22, I think, of being an in-house lawyer. So the lead safety lawyer, the guy named Kemp, he was at GM for decades, right? He's a survivor at GM. No doubt he survived that long at GM because he was a very good team player. He didn't confront engineering. They probably liked him. It's precisely the quality that made him a long-standing safety lawyer at GM ultimately rendered him fairly useless and inefficacious in this type of situation, which needed more proactive lawyering. So it's a little bit of a catch-22. I don't want to be that cynical, though. There are people who have the qualities or the skills that they've developed over the years that enable you to keep your job, but nonetheless, get things done and do what is ultimately best for the corporation. But I do think there is a tension, and not everyone can navigate that tension very well. It takes an extremely high level of judgment as well as social adeptness to be able to confront people about issues and tell them you're really not acting swiftly and you're not treating this with the urgency that it needs to be treated with. At the same time, not alienating your business colleagues. And I think that's the difficulty of being an in-house lawyer in a lot of companies.
Can I just comment on something you said? I agree with what you said, but there's one thing that I want to disagree with a little bit, maybe. You said in every company, the general counsel should identify the risks and focus on them. Absolutely correct. But I think there's always a danger when you do that, and I think it's true of Ben Heinemann's article about the culture of safety. You're fighting yesterday's war. At Intel, if you look at what were the hot items when I got there, it was antitrust. That's why they hired me. I actually been an antitrust lawyer in my prior life. And then it became patents, and it became compliance, and I remember all the various things that over the years that became the front burner items. We moved, for administrative reasons, we moved the corporate ethics department that had been in finance into legal, in part because after I got there, we beefed up legal compliance and made it a real department, and then moved ethics in there. And I didn't fully appreciate it at the time, but afterwards I came to realize what a stroke of genius that was. And the reason is this. Intel, and I'm using these examples just to illustrate the broader principle, not because there's anything special about it, has a general code of conduct that's 17 single-space pages. And it references other ones, like the antitrust code and the FCPA code and so on. Nobody knows what's in all those codes. I don't know them all. And if I did, it wouldn't matter that much because they were written a couple years ago and they're partly obsolete already. So what you need, it seems to me, more than the checklist of what are the high priority items, you need a set of sensibilities in the lawyers and in the employees, a conscience, an appreciation of right and wrong or whatever. Not because everybody's going to practice law, but because you want to have as many people in the company who have good alarm bells, who will say there's something wrong here. I think we ought to get more people involved. We ought to get legal here. We ought to get product safety here. There's something that bothers me. I'm not sure we're looking at this the right way. So I really think it's an attitude more than a knowledge that is critical, and with the absence of what I call the ownership culture, it was the attitudinal failure that at least in my sense, was the real failing in this story at GM.
I'll just say, by the way, that in his report, Valukas refers to slogans which describe two aspects of the GM culture as he found them. One is the GM salute and the GM nod. The GM salute apparently is to sit with crossed arms. The hands point to somebody other than the speaker as the person who should take responsibility for solving the problem. And the GM nod is when everybody at the end of a conference nods in agreement that something ought to be done. But nobody in particular is tasked with doing it and not given any deadlines or responsibilities for doing it. And that seems to go to Doug's point about the ownership the ownership culture. Benoit, is there anything you've heard so far that rings a bell to a psychologist?
Sure, there's plenty of bells that are ringing. Well, what you're describing right now with the type of attitudes that people bring to the table, and which I think it echoes some of the things we've heard about how these organizational processes work, certainly sound very familiar in terms of, not the attitudes of the people that make up the organization, but then the processes within the organization that lead to diffusion of responsibility, compliance, conformity. Conformity sometimes not just to the norms that are actually at work in the company, but my perception of the norm, even though I may have some misgivings about what's going on, I keep that to myself. We may all have misgivings about it, but keep that all to ourselves. As a result, I think I'm the only one. I don't say anything. That's a very common factor that leads companies to basically drive off the cliff when no one expresses themselves thinking they're the only one. The process of rationalizations we also know about seem to be at work here. There's definitely something quite interesting about the kind of looking the other way, the diffusion. As you said, this is an old company where people made it's not the Silicon Valley, so it's not a place where you switch companies by making a big bang and being recruited elsewhere. It's you make your career there, and it's possible that it selects and encourages people who stick with the plan. The interesting thing, of course, is that it would be easy from the outside to say that this is a question of having done the right thing versus putting the interests of the firm yet. But of course, that's not what that is. It's to some extent long-term versus short-term, and certainty versus uncertainty. The role of a general counsel is like, do I raise the issue now and cost the company something and maybe get some grumbling from the CEO? But of course, with the benefit that I'm saving the company millions of dollars down the road. And so it's not just a mistake of not wanting to rock the boat, but a mistake of also getting the company into trouble and costing the company huge amounts of money. It is, as an outsider, it is interesting to get some glance into the work of the general counsel in these situations, all these issues of Was money an issue or not for safety? The outside company that comes in and says, there's a risk of punitive damage down the road. And again, it shows, I teach ethics for management, and it's really interesting once we get to the legal field to see how quickly these breaches actually cost money, and to what extent are we talking about a strategic decision about saving lives, and how quickly it becomes a decision about saving lives, because that's going to cost us a lot of money. And I think there's an interesting perception issue from the outside of the role of the counsel and legal in general, which I think is probably largely inaccurate, but I think is interesting to put on the table. And we were just talking about, one vastly misrepresented case in the legal literature and the liability literature, which is the Fort Pinto case, right, which legal students always hear about, and business students do also. And I know there's a lot of misrepresentations there, but I think it touches a nerve, perhaps because of the misrepresentation of the general counsel. It'd be interesting to hear about that also, in the sense that there's this perception that they're making Machiavellian strategic decisions, right? If we fix that, it would cost that much money, but at most our legal cost would be that much, and so it's worth it to go ahead. And I'm convinced that's not what goes on, of course, in the GC suite. But I think it's interesting to recognize it, because it probably affects why some stories have the impact that they have in the media and so on. Other issues that are interesting, you talked about NHTSA. I don't actually know how much of a revolving door, is that the phrase? I don't know how much of NHTSA is made out of former car company executive. I mean, it's quite, obviously their incentives should have been quite different, and it's striking that they did even less apparently than the companies did. And so there's interesting things there also about incentives and familiarity with the risks, with the people who are at risk and so on.
Well, the auto companies are pretty effective at lobbying the Congress to ensure that NHTSA's budget and NHTSA's staff are not up to the regulatory tasks that it's supposed to perform. So that of course is part of the story, but of course that then Congress calls all the NHTSA regulators on the carpet for not doing their job when something goes wrong. The one question that one might ask about here is why general counsel? Why would general counsel's office sort of be the catchment point? Right. Why would the basic responsibility for a company's discharging its ethical as well as its legal obligations be focused in that office? Are there good reasons for that?
Well, I think there are. I mean, I don't know that the combination of ethics and legal compliance is common. I mean, it's happened that way until I came to think it was actually terrific. But I think there are two very good reasons. One is one's analytical, one may sound snobbish. The analytical one is this. You mentioned when you were going through the slides that GM had financial troubles, and that notwithstanding declarations about safety comes first, money matters. And I don't know whether anybody here remembers it, but Holman Jenkins in the Wall Street Journal wrote a piece in which he said, look, the real problem is GM was losing money in the cobalt. That was because of government fuel economy requirements, and if they hadn't been for the government fuel economy requirements, they wouldn't have been losing money. If they hadn't been losing money, they would have taken care of the car. I mean, it's complete nonsense on so many levels. But there was a great of important truth to it. And it is a lawyer's responsibility, it seems to me, goes up when there is reason to believe that the other people in the company might have incentives that are not appropriately aligned with the long-term interests of the company. And people who manage profit centers in a company often have short-term incentives, right? Nobody wants to recall a car and have it show up on his quarterly P&L when his bonus depends on that quarterly P&L. The lawyer, of course, is running a cost center, so he doesn't have those kinds of sensitivities. So the lawyer really is in a position to take a longer view, as Benoit was saying, about the interests of the company, and be a little bit removed from some of the perverse short-term financial incentives that might make others in the business community, in the business group, a little less able to act with that longer view. That's one. The other thing is this, and this is something I actually came to in a phone call I had last night with a friend of mine who's a lawyer at a tech company who was talking about some intrigue at the highest level levels of the company, and I had the following, which I'm going to suggest this is an hypothesis rather than a proposition. And it is that, because I blurted out to him, I said, the problem is your company's full of engineers. I bet none of them took a history course or a philosophy course in college. And leaving aside the preposterousness of the statement read literally, lawyers have a different sensibility in their training. And maybe in ethics professors in business school do as well, but I used to live in a lawyer's haven in Washington, D.C., and it's just a different world from the business world, at least from the tech business world. And that may be another reason why lawyers are unusually, if not uniquely, well suited to be the shepherds of ethics and compliance in the conscience of the company.
Though isn't it often those very characteristics that lawyers have that make business people distrust them?
Sure.
Yeah.
I do think lawyers they add value to the company by being able to identify and, to a certain extent, estimate risks. The cost issue permeates the whole story. It's the background of the entire story, and I think it's something that we can't discount. Ray DiGiorgio, who was the original design engineer, approved the faulty ignition switch for cost reasons, but also because he had to meet the timely production schedule. He was also reluctant to repair the faulty ignition switch in a timely manner because of the cost and production schedule reasons. So he implemented a series of Band-Aids that didn't really resolve the problem. So we have cost and the emphasis on cost control at GM that permeates the fabric of the whole culture as an engineer in the report described. And this is where lawyers can be very effective, and I think lawyers are, to a certain degree, and we're not unique, but we're to a certain degree equipped to be able to address these issues by saying, it's fine to emphasize and control costs, but safety comes first, and lawyers can put the brakes on the system. What I find surprising about the report, and maybe it's because I don't understand the automobile industry, it's not an industry I'm familiar with, is that there was nothing in place, no policy or protocol or discussion of what to do when you know that something is wrong, i.e. the airbags are not being deployed, but you don't know the cause of it. You don't have a quick fix, right? So the automobile companies, they usually issue a recall and they do something like, I have a Toyota Prius, changing your the rug underneath your brakes that would prevent the acceleration or increase the acceleration when you didn't intend it to. So it's easy to recall when you have the fix. But if you don't have the fix, what do? What is the protocol in place? And so that's a situation that I would like to categorize using sort of Don Rumsfeld's terminology as sort of a known unknown. You know something's wrong. The airbags are not being deployed in certain crashes and certain models, but you don't know why. What do? And that's where it doesn't seem like the people at the top had ever anticipated that type of situation, even though I would think it's clearly a foreseeable risk that there will be a situation when you know something bad's going to happen, but you don't know the root cause. So I was a little bit surprised there wasn't some sort of policy in place, but maybe I'm asking too much from the automobile industry. Those are the types of situations where I think a lawyer, like a general counsel, could say, we need to deal with these situations. We need to at least have a system in place to think about these very, very costly recalls, which nobody wants to do, but may have to be done.
Benoit, any thoughts?
Well, I certainly don't want to defend GM, but in hindsight, I feel like it's easy for us to look at DiGiorgio with that one part and maliciously, or not maliciously. I mean, I guess there's that whole question of malice versus competence. But making that decision and losing track of the fact that GM was probably making decisions about thousands of pieces, each of which had a risk associated to it, many of which are still in the cars and have just not have led to some deaths, but not enough deaths to come on our radar. So I don't think that's a solution, but I think it's a context to really keep in mind. When I think, Doug, you were saying fighting the last war, I think there's some of that. Is that how do you aggregate the information so it's really bottom up and not top down of like, I'm going to look at this, but to be able to hear that data. And then the question is that, I think as is emerging from this discussion, is that a legal question? Or are we able now to have systems in place that integrate all that information and raise those flags when we need them? But again, it's when we tell the story, there's a very clear A to Z with wrong choices along the way. I think it's important to remember that it's kept both by engineers and lawyers. It's in the context of the thousands of those choices, not just about engineering, right? About HR policy, about all the other things that GC is considering.
There's just one other thing that Benoit, your comment prompted in my mind in response to Bob, your question. Why lawyers? Mm-hmm. This isn't unique to lawyers, but it does differentiate them from most of the components of a big company. Lawyers cut across the whole company. All companies, big organizations, have to be somewhat siloed, right? You can't just have a committee of the whole. You have teams with tasks, but no org chart can possibly capture all of the required inter-silo or inter-team communication because you can't envision it all. It's a problem tomorrow you hadn't thought about. It just so happens that lawyers, like I suppose HR and maybe finance, touch upon all of the operational units. And, in Intel we had 400 lawyers. Intel has 100,000 employees. It's going to be a lot harder for 100,000 employees to figure out who else in the company should I call than it is for a lawyer to ask who else in the law department should I call to make sure that his component is aware of this situation. Mm-hmm. So in that sense, the legal group and maybe a couple of other support groups has a vantage point in terms of cutting across the operating units. That is another reason, it seems to me, why it might have this responsibility.
I wonder if, I know in the accounting world, to try to reduce the cost of the accountants having the wrong incentives to approve whatever the company puts on the table, I think there's rules now about, first they try to have longer contracts so they don't get renegotiated, right, short term. And there's also rules about not having the same necessarily company.
To rotate the audit
The auditors, yeah.
So, I guess one question was, we've talked also about the trend from more legal firms to in-house lawyers. Do you think this has any impact on the issues we're talking about? And if it did, are there rules about rotating legal partners, for example, that would ensure independence? Or is that anathema?
That's interesting.
Well, I think change is good, but we didn't do a very good job at Intel of rotating in-house lawyers. I do think lawyers in companies, I think some companies do it differently. I think lawyers should report to the general counsel, not to the business units, so that they have a little bit of independence. It still requires the general counsel to say to the board or the CEO, I got a problem for you. But I think that's good. The notion, to me, it's not so much corruption and selling out and other things that have been adverted to, so much as it is a kind of staleness, a loss of distance and perspective. And I think you point out an important problem.
I want to go back to Benoit's comment on the issue between whether it's neglect or maliciousness. And it seems pretty clear, with the possible exception of Ray DiGiorgio, the design engineer, there may have been moments when he deliberately concealed what he was doing. And that's understandable. If you make a really bad mistake, it made sense for him, if you put yourself into his shoes, to order a part change without changing the part number, which unfortunately obfuscated a lot of other people's efforts and prevented them from learning the truth of the matter. But with the possible exception of that engineer, most of these mistakes were mistakes of neglect, incompetence, some people would say stupidity. I'm not sure if I would go that far, but clearly the degree of incompetence and inefficaciousness. So most of the problems I view as being fairly banal. And so what do you do in that situation? It's a cultural problem where you have people not really wanting to confront hard issues and roughing feathers, perhaps, and for that matter, communicating clearly. So the legal department clearly failed in that regard. There was one situation when the lead safety lawyer was trying to sort of ask the chief engineer of the company to champion this issue. And the Jenner and Block, Valukas, interviewed that chief engineer, and he didn't understand what he was supposed to do. He said, I thought I was just going to find the solution. I didn't think that they wanted me to investigate the matter and determine the root cause and ensure that the team had the proper resources to find out what the root cause of the non-deployment was. And so there was a huge communication problem here. And lawyers are generally thought to be good at communication, so it's a little bit surprising that they were so poor, that there was a mismatch. And I'm not saying it was the lawyer's fault, it was probably also the chief engineer's fault.
Yeah, isn't there a cultural problem? The chief engineer should have asked himself, since he has the word chief, he's kind of senior, is that an appropriate assignment under the circumstances? And if not, shouldn't I see that somebody has the right assignment?
I totally agree. Clearly the engineering department had a deep problem. For the chief engineer not to realize that this was a really urgent matter and that non-deployment meant fatalities and that this was something that was high priority is appalling. But I feel the same way, at all levels of the company. Everyone in an executive level position should have kept abreast of major fatalities. I mean, I really think that ownership of the problem includes the ownership of the problem at the very top, at the CEO and the GC level. If fatalities are happening, and there was a record that cobalts during certain years had the highest fatalities of any car in the U.S. They were in the top 4 categories. That should have told them something, and for them not to have the basic facts of which models were generating the high levels of fatalities in the U.S. among all brands, among all manufacturers, for them not to keep their hands on that information, not to be abreast of that type of information, I think it's pretty surprising.
But so cars are a dangerous product, right? I mean, if I was putting computers out there and people were dying, I think they would obviously be a red flag that would escalate. But not to trivialize things in any way, because obviously there's a lot of social goods that come from having cars, but you put a car on the road, a lot of people are going to die in your car. So I feel like now we think, oh, wow, there's someone died, they should have known something was wrong, but every brand of cars has people dying, maybe not every day.
But non-deployment of airbags, by 2007, there were 4 cars that crashed, ended in fatalities, and the airbags did not deploy. That's a pretty strong red flag. And the legal department, as early as 2007, knew about these 4 cases. Now, there were some causation confounds, so they didn't know the root cause of it, but nonetheless, these were fatalities that were caused by the non-deployment of airbags as early as 2007. I'm surprised that the GC didn't know about that.
Let's open this up to participation and questions from the floor. Because this is being recorded, I would ask that if anyone wants to ask a question or make a comment, that they come to the microphones here, because otherwise the recording equipment will not pick up the sage comments that they are making.
So what are the solutions?
We're dealing with human beings. You look at that problem at GM and you say, what are the new procedures we ought to institute so this kind of thing doesn't happen in the future? That's a small step, but it's the fighting yesterday's war kind of problem. The real thing is consciousness raising, and that's a constant battle dealing with fallible human beings. I think. I don't know. Some of you guys may have a different view.
I agree. I mean, it's a deep cultural issue, but I think in some ways it's endemic to firms and also lawyers. I mean, there's a tension within the role of being a lawyer. You are viewed both as a mere advisor, and I don't mean to be that sardonic, but an advisor that advises business people. And it's clear that the lead safety lawyer and the lawyer who was head of products liability cases had sort of a limited or more impoverished view of their role as sort of facilitating things along. And I get that. That's a very common view of lawyers. But once you're in-house, sometimes the buck stops with you, and you are expected to do it a little more than you would if you were an outside lawyer. Ben Heinemann says there's a partner-guardian tension. I like to think of it as an advocate-gatekeeper tension within the role of the in-house lawyer. And reconciling those two somewhat conflicting views is tough. But if you're aware of that conflict, and you know that as an in-house lawyer, in some ways you have a stepped-up responsibility to address these issues a little bit more urgently and directly, I think that will help a lot.
Sir.
Okay, so it seems to me that the general counsel was probably a brilliant lawyer because he got to be GC, but as a manager probably deserves an F or below that. I keep thinking about, today's election day, so it reminds me about Harry Truman, and he had a sign on his desk, "The buck stops here." There's no question of ownership in that case. But Hewlett and Packard, which both went to school here, had this idea of management by walking around so that you would know as a manager what your people are doing. So I'll have a question for Doug. You've got 400 attorneys. That's a big group. How do you keep in touch what's happening in the Intel law department?
Everybody has a different style. Mine was probably not the best, actually, because I tended to rely on my staff, the people who reported to me, to keep me informed about what's going on within their components. Others, I think, probably, using your metaphor, walk around more and probably reach down more. In a company the size of Intel, you're handicapped by geography. We have lawyers all around the world, and only a small I'm not even sure if a plurality were in California, maybe in Oregon. So you're handicapped, but it's a real effort, which is why I think to me the failing at GM or any institution like this, with the benefit of hindsight, is not so much processes as and maybe the general counsel should have walked around, but at the very least he should have said to everybody in his department, make damn sure I know about the things I should know about. Yeah. And I don't know what they are in advance. I'm going to rely on your judgment to tell me.
Okay, so you're using the people who report to you as the eyes, your eyes and ears, extensions of your eyes and ears.
Right, and welcoming people below, inviting people below them to come to me directly if they feel that information is being improperly stopped on the way up.
Okay, thank you.
Maybe the simplest thing that could have been done in this case is lower that 5 million figure, right? I mean, there's in effect, there's a wall between the GC and a lot of the information coming up. If nothing's elevated, if it's lower than 5 million, of course you've got precious time.
Well, yeah. So the general counsel is making decisions about how to use his time, and he's doing something that we would have looked at as a positive, right? He said, "Look, if it's 5 million, I want to hear about it." And now, in hindsight, people are saying they took away the message. If it's 4.9, I don't want to hear about it. Yeah. And the problem is the second half of the message, the implicit part. Seems to me.
Do you think that's a misinterpretation that could have been fixed with a lower figure, or? Well,
I assume again, with hindsight, what I would have said, if you determine 5 is the right number, considering all the other things you have to worry about and the numbers of deaths and whatever it is, if you determine 5 is the right number if it's 5, I must know about it. You have to make sure you add, and if it's below 5 and you still think I ought to know about it for some other reason, make damn sure I know about it.
That's right, sir.
So first of all, this is the kindest panel of lawyers I've ever been around. I'm from the accounting profession, so I'm probably the one person here who is not a lawyer by trade. The question I'll ask is, what do you think the impact of really implementing deeply the tone at the top and Sarbanes-Oxley played or didn't play in this activity? Because having been with a major corporation of roughly the same size, it's hard for me to believe that risk assessments quarterly that went to audit committees that really deeply looked at organizations and what was going on, this didn't bubble up in some form or other to a general counsel or to a CFO who saw these assessments booked and some decision made about how much they would or would not escalate the issue that was going on. So it's hard for me to believe that people really decided that, or it was so fractured that no one knew that this was an issue. And so I'd just like to have your thoughts on the Sarbanes-Oxley implementation, your partners in finance and the role that they play, because typically the GC and the CFO are joined at the hip, and a CFO also has this view of the company as a whole.
So unfortunately, based on my recollection of the report, it doesn't address the Sarbanes-Oxley issues at all. And one limitation is that Sarbanes-Oxley applies to lawyers appearing and practicing before the SEC. So these are lawyers that advise on securities disclosure matters. And unfortunately, even though they are responsible for disclosing these types of risks to the public via the 10Ks and the 10Qs, the report doesn't address that at all. And Sarbanes-Oxley Section 307 mandates internal whistleblowing for material violations of law, but those are imposed on lawyers practicing and appearing before the SEC. And I'm not sure, and it's not clear to what extent Kemp would be that. You would think that because he is the lead safety lawyer, or at least Larry Bonema, who's the head of the products liability cases, they would have some involvement and could be deemed to be lawyers practicing and appearing before the SEC, but it's not clear whether or not they fulfill that definition. But the report doesn't address that at all. So I can't really add much more than that, but clearly they fail to elevate the
also,
issues.
you would think there'd be a compensating control with the financial arm.
You mean the board? Yeah. The board, the description of the board was a little bit vague. It seems like the board didn't have much information. They were responsible for quality, and safety was included in quality, but I don't think they had it's not clear, but they didn't seem to have that fine detailed information that really said cobalt, non-deployment, fatalities. So from my recollection of the report, there wasn't much there. Is that your recollection?
I have no recollection about that issue in the report.
It seemed to me from reading the report and Valukas doesn't dwell on this much because Valukas is very focused on the failure of airbags to deploy as the main problem that they failed to detect. I keep going back to the fact that they had hundreds of complaints that the thing was stalling out while the car was in motion. And that's a potentially dangerous defect in most forms of heavy traffic conditions. And if you recognize that as a potential safety issue, then you might also start to ask the question, and what else happens when the ignition turns off? What else happens is that the airbags fail to deploy. I think nobody asked that question because they were wedded, I think largely for cost reasons, to the classification of the involuntary, the accidental stall as a consumer convenience issue rather than a safety issue. They reported it to NHTSA that way, and they dealt with it that way internally. That I think, and it doesn't seem to me you need hindsight for that because contemporaneous observers, many drivers, and the Cleveland Plain dealer, and some of the regulators too noticed the problem at the time and commented on it. It's not. I think this is not something from the wisdom of hindsight. And but the thing was, somebody should have done something about that. But who? That's Doug's point. There was no particular responsibility for taking care of it. Sir.
You stood up 3 times. I'm curious what you got to say.
I'm sorry. I'm looking not necessarily cynically, but at the economic impact. It seems to me that delaying the announcement and recall means you don't recall as many cars. It means you get the profit on the cars or on the money that you've saved over the few years. So for the company, direct economy might be benefited by having some delay. For the individuals, were the individuals who were in these command chains punished directly, or did they just lose their job and they got their bonuses from the time before that? Now, I'm not being cynical. I'm just trying to balance out whether economically this situation was not that bad for the company directly, not loss of niceness or whatever, or future jobs. Question.
Let me suggest, I don't know. It could well have been profitable, but I think that the answer to that question, I don't think has a lot to do with the discussion we're having about whether there's something wrong in the culture or the processes at General Motors, because there, as far as I understand, nobody made the decision that this was a profitable course. So it would have been fortuitous if it turned out that it was a profitable course, rather than a situation where young people brought to the General Counsel this pattern, they looked at it, and they said, oh my God, we've got a problem, and then they sat down with the CEO and said, did we recall the cobalt? And he said, no, because I think we can make more money. That would have been arguably a rational economic decision. Yeah, well, then you have to take into account the legal significance of having made that decision, but it would be a different story.
When King and Spalding, the outside lawyers who were defending the products liability cases, submit a report to the GM management that says this is a potential punitive damages situation because the failure, the switch cutoff means the airbags failed to deploy, and this is not a business decision that we can defend. So once they start saying that and mention punitive damages, that's a potential monstrosity of cost considerations that could materialize. So that gets people's attention. By the way, the whole thing gives me renewed respect in many ways for the tort product liability situation. The regulator didn't see the problem, internal management didn't see the problem, but plaintiffs' lawyers and their experts did see the problem. They brought the cases that came to the attention of management, and they also provided valuable information about causes, which was not accessible to the company. So despite all of the bad things that are said about plaintiffs' tort lawyers, they do have their uses and fill gaps which regulators sometimes are unable to fill. Yeah.
So I thought about when you were describing the anomaly in the slides. In May, LA Times released one of the documents that was released to NHTSA as part of the settlement, and one of them was a document internal to GM that had 69 words not to be used in internal communications. As I listened to this whole panel, it would have been hilarious if you had done it and never used those words, which included dangerous, safety, defect. And so, and that together with the description of this being a convenience issue as opposed to a safety issue, what meant people internally, if they were following the rules of this, would have not been able to use language. Have been very important to really point out that this is a safety problem. And what I'm curious about when you talked about the culture at GM is if this document came out, that wasn't just culture or someone not worried about making waves. It was now codified into a set of rules. And depending on who approved this they have now just told people, don't tell me about problems. I don't want to hear about it. And maybe in a sense of we don't want internal documents to cover ourselves later or something. But the fact that there were 69 words, now some of them I thought were kind of funny. They were Corvair-like, any references to Challenger, any biblical connotation. So some of them were very incendiary. But problem, defect, defective, dangerous, and the word safety were explicitly not supposed to be used, which meant that if an internal, within the family communications started being watered down at the first level. So it did work into counsel for this individual sections, anything else. It kept it watered down for a long time. So is a document like that, part of the problem? And should there even have been a document like that in order to water things down later that then could balloon into something like this?
I'll take a stab at that. That sounds to me like a pretty dumb document, partly because if it falls in the hands of people as it has, it holds you up to ridicule and probably inflames juries. And probably more importantly for the reason you state, which is if they take common words like safety and prohibit using them, they probably interfere with communication that needs to happen in order so that they're not steering blind. But companies, certainly Intel is one of them, regularly wind up writing big checks because words that are used by people who maybe didn't study the nuance are taken out of context or given a lot of meaning in the legal process by government enforcers or by juries, by judges. And so I think it's a perfectly legitimate and important part of the lawyering process to try to say to people, don't say, I'm going to kill the opponent. Say, I'd like to win this competition. I mean, you try to put it in a vocabulary that won't be inflammatory. So I think conceptually what was going on there was not inappropriate, but it's my guess is they did it in a pretty destructive and heavy-handed way.
I agree. I think the lawyer's role is appropriate when the lawyer says, be careful of what you say, be mindful of the meaning of your words. Think about it. If it was on the front page of the New York Times, how would you want people to react to what you've written? I think that's entirely appropriate. But clearly, GM was a little different, and it's in the report they talk about the person who was responsible for issuing the technical service bulletins to the dealers, warning the dealers of certain defects. And he always did the first draft, and then he showed them to other people at GM, and then they would look over the language. And sometimes he would use these, quote, hot words like safety or defects. Invariably, they would tell him to take those words out. But the problem is, if you don't use words like stall, like they didn't want him to use moving stall or stall, which describe the problem accurately, it would be very difficult for the dealers to actually search for those bulletins when a customer would complain and say, I have a moving stall problem. How do you deal with that issue? And what's interesting is, according to the report, the person who was responsible for these technical service bulletins, he did not fight the issue, even though he himself claimed to be caring about safety issues and defects and so forth. He didn't want to push the issue too much because his perception was that his predecessor in that very position was pushed out of the company for overemphasizing safety. So there's a lot about the culture of GM we don't know. But that one statement really struck me as, wow, that's really bad.
I'm afraid we're going to have to end here. We've overrun our statutory time limits, and we'll be subject to severe penalties if we go any further. But I want to thank the panel for a terrific